Hello, my name is Mike Moyer. I'm the author of Slicing Pie, and welcome to today's Slicing Pie Legal Clinic with one of my favorite Slicing Pie friendly lawyers, Jennifer Rohleder in Washington, D.C. Say hello, Jennifer.
Glad to be here. Hello, everyone. Glad you could join us.
Thank you very much for being here. Today we're going to go over some legal issues that you will need to keep in mind when you're dealing with the Slicing Pie model. And people all over the world, high and low, near and far, use the Slicing Pie model to make sure they have a perfect equity split in their startup company. And as they go through this process, occasionally they bump into issues that need to be addressed from a legal standpoint. I always say that Slicing Pie is more of a moral agreement than a legal agreement. It's about doing right by the people who get you to where you want to go. And it's important to always keep in mind that doing right is the first thing you want to keep in mind, and legal is the secondary purpose, but always want to make sure you're doing the right thing. Sometimes when you hit a wall legally, you find someone who can't help, just rest assured that I'm always available to help people figure out the legal issues, as well as the Slicing Pie friendly lawyers, which Jennifer is one of them. She's outside Washington, D.C., and she's been a Slicing Pie friendly lawyer for several years, about over at least a year now. And she helps people all over the country implement Slicing Pie contracts, and she's available on our website under resources, under attorneys, and you can find a legal template that she wrote for making sure that your grant fund is legal and in line with the applicable tax laws and things like that. So I'm Mike Moyer. I'm the inventor of Slicing Pie. Slicing Pie was published in 2012, and since then I've had sold thousands and thousands of copies all over the world and spoke at events all over the world, and it's been wonderful to watch Slicing Pie grow. And there's attorneys in different countries that are Slicing Pie friendly that I can refer you to. But of course, we're busy in the United States, in the English-speaking countries, because the book was published in English at first. On the call today, there's about 300 people registered for the call today, or 350. And it looks like most of them are still kicking the tires in the Slicing Pie model. I hope this will help you tip the scales in the favor of Slicing Pie and pick the fair solution. In a couple of cases at the bottom, your lawyers talked you out of it. Dynamic equity to an attorney is often a confusing thing, and it poses a number of different problems. And so when a lawyer who's not familiar with the Slicing Pie model hears about Slicing Pie, they may be very skeptical and try to talk you into a traditional model. I hope that you will see today that the legal issues can be handled pretty straightforward, and that there are legal resources to help you do it. So if your lawyer tries to talk you out of it, you can put your lawyer in touch with us or find a different lawyer. But most of the time, we like to work as much as we can with lawyers out in the field to make sure they can have the tools they need to implement. Also, it looks like of the people, because you're not a lot of using it yet, not a lot of you use a legal agreement for Slicing Pie, which is fine. You don't necessarily have to have one, but it's always nice to have things in writing to move forward. If your company gets any traction, you'll need that in place. I want to remind you that the basic principle behind Slicing Pie is that a person share the rewards of a company. That means profits or the proceeds of a sale. The share of those rewards should always be equal to that person's share of the risk. So if I take 10% of the risk, I should get 10% of the reward. If I take 50% of the risk, I should take 50% of the reward. If I take 100% of the risk, I should get 100% of the reward. That statement should be obvious. When someone puts something into a startup company, whether it be time or money or ideas or relationships or facilities, they're risking that contribution on the future rewards of that company. The amount of that risk is always equal to the fair market value of that contribution. Everything that has a fair market value, and it can be used to calculate your risk using the Slicing Pie formula, which you should know if you haven't read the book. It's basically all the fair market value of your contributions are converted to slices, and the slice is a fictional unit of equity, of risk. And your share is always equal to the slices that you contribute divided by all the slices in the pie. And this will always guarantee, no matter what changes, you always have exactly what you deserve to have. So things do change, and your share at any one time could be different. And a lot of people find this uncomfortable. They think they'd rather have the certainty of a fixed equity split, of having a known amount of equity. When someone gives you a fixed chunk of equity, 5% or 10% or 20%, the only guarantee is that you're going to wind up renegotiating that split later on down the road. A fixed equity split, in my experience, has never actually ended up to be the same way people envision it to. So if you want to have certainty, don't join a startup company. If you want to be certain that you get what you deserve to have, use a slicing pie model to make sure you get what you want. So I hope that through your research on slicing pie and reading the books and seeing seminars like this, that you will agree that slicing pie is by far, without a doubt, the most fair way to divide up equity on the planet. So I'm going to go through your questions. Some of the questions we prepared in advance, and some were the ones that you submitted when you registered. The first thing I want to address, I was going to read the questions, and Jennifer and I will respond to them as we go through. The first question is, where can I find good advisors relating to tax on dynamic equity? And Chicago and Australia and New Zealand and in the UK, and I'm trying to find connections with attorneys in
Mike, I'm not sure if everyone on the webinar is having the same problem, but I think your microphone cut out.
Jennifer, you have something to add there?
Oh, I'm sorry. Your microphone cut out. I couldn't hear you for the last minute or two.
Oh, that's too bad. What?
And it looks like on the comments here that we've got other people having the same problem. So maybe you want to repeat your answer to the question, and hopefully audio is coming back.
Can you hear me now?
Yes.
So the question was, where can I find good advisors relating to tax and dynamic equity? The answer is all over the world. There are good advisors that can provide guidance with regard to slicing pie and taxes and dynamic equity. If they are not familiar with the slicing pie model specifically, please feel comfortable coming to slicingpie.com and working directly with us to find the resources you need. I don't want anyone to start kicking the tires on slicing pie and walk away because they think they got the wrong advice. Slicing pie is by far the most fair model in the country, in the world, I think, to do this. So I hope they make sure you take it seriously going forward. The other question we get a lot is, do you launch it as a partnership, a corporation, or an LLC? Jennifer, you want to take this question?
Sure. And you know, just to prove that I'm a lawyer, I'm going to start it off with a very lawyer phrase, which is, it depends, right? And every expert that you talk to is going to have a different answer. But for the most part, you know, here's a couple of general rules of thumb. A partnership is great if you are getting together with a couple of co-founders and you're in the proof of concept phase. You're trying to figure out, is your idea going to work? Is there really a business here? Is there a market? All of those questions. You're not selling to anybody yet. You're not, you know, you're not really engaging with outside folks yet. And so getting together in a partnership saves money, it saves time, but there is no liability shield. So if you do end up entering into any contracts or anything, it's going to go back to the partners personally. A corporation provides you a very nice liability shield, and particularly if you're going to be considering launching a funding round in your business within the next 6 to 12 months, you should definitely, I think, create a corporation. Most investors that I've interacted with are more comfortable with corporations. Some of them are actually, for tax reasons, prohibited from investing in LLCs. And so, so if you know you're going to do an outside funding round in the near future, you might as well just start out as a corporation. And before anyone throws the double taxation issue at you, it's a complete red herring for an early stage company. You're not going to be issuing dividends for quite a while. And once you do, that double taxation is a really great problem to have. So I wouldn't worry about it. I wouldn't worry about it up front. I personally have a thing against LLCs. The fact that they're very flexible and you can create any kind of managerial structure you want is a positive, but it's also a real negative I've found for early stage companies. It's especially if you're new to having a business or running a business, you kind of need to already know how you want things to work in order to make the LLC really work for you. If you're still kind of figuring it out as you go, having the general structure of the corporation as opposed to the ultimate flexibility of the LLC is probably better. But these are all kinds of things that, you know, it's going to vary depending on your own specific circumstances.
And certainly different lawyers have different preferences. Like you said, you like the corporation better, and that is absolutely reflected in the contracts that you've created for Slicing Pie. There's another lawyer in Chicago who prefers the LLC model and has written an operating agreement for the LLC. So you want to pick the one that works best for you and pick the lawyer who can support your decision regardless of what you choose. But you'll find that Jennifer does clearly like the C Corp and S Corp structure better than LLC. And that brings us right into the next question. Should we incorporate in Delaware? Jennifer?
If you're located in Delaware, then absolutely. Otherwise, probably not. I don't think anyone, any stakeholder that ever gets involved in your business is ever going to wonder why you incorporated in the same state where you're located. Particularly for an early stage company, you want to keep things as simple as possible with respect to governance and compliance, as well as the annual fees that you need to pay. So if you incorporate in Delaware, but you're located in Missouri, Michigan, California, somewhere else, you're going to be paying registration fees both in Delaware and the state where you're located. You're also going to need a registered agent in Delaware in addition to where you're located. So it adds complexity without adding much in the way of any value. At any time in the future, if there's a reason for you to move the company to Delaware, you can very easily do that. If you're hitting a large investment round and that's what the investors want to see, then absolutely you can spend a couple $100 then and move your company to Delaware. But as you're getting going, I wouldn't worry about it.
By the time you've raised your Series A, then you can afford all the hassles that go along with being a Delaware corporation. But as in a startup, it's not worth the effort. The next question is, what is the proper documentation of the business agreements and governance? And with regard to the Grunt Fund specifically, I'll let Jennifer talk about that one as well.
So particularly with respect to the Grunt Fund, you definitely need to have a written agreement. I always advocate for implementing the Grunt Fund agreement separately from your governance documents. So while you could bake it into either the bylaws of your company or your LLC operating agreement, the whole point of the Slicing Pie model is that once you're no longer a startup, it goes away and you're going to move into a more traditional corporate structuring. And so it's it doesn't make, to me, it's like, you know, just adding this element that is just going to completely disappear from the governance documents of your business. So keeping it separate is good. It also then keeps the Slicing Pie approach within the realm of contract law. And that's a really good thing, because if anything was to ever go wrong and you needed to go in front of a court or an arbitrator, they're going to take a look at the Grunt Fund, at the dynamic equity model, under the lens of contract law and use contract interpretation principles. And it doesn't get wrapped up into state nuances of employment law, corporate governance, and that kind of thing. So if you're gonna go forward with a slicing pie approach, you really want to have it documented, and anyone who's going to be involved with the company and coming in under the grunt fund needs to sign it. In addition to that, there's all the other corporate governance type documents that you need, and getting into issues of invention assignment, and non-disclosure, non-solicitation.
Now, Jennifer, I've had attorneys tell me that the book Slicing Pie is detailed enough that if you could show there was a verbal agreement to do slicing pie, that the courts would uphold the description of how to implement in the book. Would you agree with that?
I think it's possible. I think it's definitely possible, but when you're dealing with the verbal agreements, it becomes a he said, she said, and so that it's definitely more risky
Right.
to do it that way. So I don't think it's fatal. I think you could definitely go that way, but if you had a dispute later on, it's going to make it really tricky to try and resolve it in any way that anyone feels good about. So
good writing.
Yeah.
So this is a common question with regard to how do I minimize tax consequences when the pie gets split. One thing I want to say here is you owe the taxes that you owe. You always owe taxes that you owe. So whatever your taxes are is your tax bill. Slicing pie should not shield you from taxes. However, how you structure your slicing pie split can impact the taxes that you owe. And there are a number of people that can comment on this. And Jennifer, you want to take a whack at how you should structure this?
Absolutely. I do want to caveat that I am definitely not a tax attorney and in no way a CPA. So I have enough knowledge to be dangerous, perhaps. But one of the primary concerns from a tax perspective is when the individual grunts receive the equity. If in a fixed equity split, you get the equity all up front, maybe it's subject to vesting, maybe it's not. But if you get it all up front and the company's brand new and not worth anything, then your taxable consequences are negligible, if anything. In the pure version of how slicing pie was portrayed, it's not until much later, after a lot of work has gone in, cash infusions, equipment, other things, the company then has value in the market. And so if you wait until the point where the pie freezes, the taxable consequences of getting the equity then could be much more significant because the stock's going to have value because the company has value. So a way around it is in order to take advantage of the IRS Section 83B, which says tax me now, IRS, don't tax me later. It sounds counterintuitive, but it's actually issuing everyone in the grunt fund stock up front, which seems bizarre, but here's the deal. If you have, say, 4 people in the grunt fund in your company and you're all signing on at the same time, everybody gets issued, say, 100 shares up front, but they're restricted shares and they vest according to the grunt fund. So, and the grunt fund tracker. So the way that it works is every month you're using the accounting, your accounting document to keep track of all the inputs, and say everybody has an equal contribution the first month. Well, everybody vests in 1 share. In the next month, perhaps 2 people do all the work and the other 2 people are sick, on vacation, whatever. The 2 people that did work vest in another 1 share apiece, and the other 2 don't vest in anything. And so on and so forth. So it's additive as you go along. When you get to the point when the pie freezes, any leftover shares revert back to the company because there's no way to vest in them anymore. And because you were issued these restricted shares right up front, your 100 shares, you can take your 83B election so that you're getting taxed right now when the company isn't really worth anything or worth significantly less than it will be later. That's it creates some more paperwork, but it does help minimize some of the taxable consequences of the equity split.
So in a typical company, you would issue restricted shares and then a time-based vesting. And time-based vesting would say over a year or 2 or 3 years your equity would vest. And that allows you to do this 83B election and avoid your tax consequences later on down the road. Slicing pie replaces the time-based vesting with slicing pie vesting. So it's the same basic model, just instead of basing it on time, you base it on the slicing pie model. And that really solves a lot of problems and makes the C Corp a nice structure to use this within. So if the company has already been formed, how can the grunt fund be implemented for us? So this question I get quite a bit because most people discover the grunt fund after they're scratching their heads with their current split. And someone might form a company and create a 50-50 split or a 60-40 split or whatever it is. And then they realize pretty quickly that's not going to work over the long term. So they start looking for. So I call this a retrofit. And there's a retrofit guide online that you can use to calculate what the split should be. And it'll tell you how many slices each person has and allow you to start with a basis going forward. However, you'll need to document that. And Jennifer, you want to comment on some ways that they can do this?
Absolutely. So if you're already in a company, for instance, that has a 50-50 split, just for ease of math off the top of my head, if you decide you want to go ahead with the grunt fund and both of the co-owners are on board with it, you can take a look, for instance, at the contract template that I developed that's available on Mike's site, and you'll see that so you can go ahead and execute that contract. The board of the company would adopt the contract as a significant company action, and the owners will pledge their existing shares under the contract, meaning that they are saying, yes, we currently have these shares, but we are putting, we're not going to impair or do anything with them, and we're putting them under this contract so that when the contract terminates, i.e. when the grunt fund freezes and the equity is redistributed, we agree that our shares will get reapportioned according to the grunt fund and the percentages therein. So in all likelihood, someone's going to wind up with more and someone's going to wind up with less and than what they were initially given. And so as part, there's going to be some legal documentation that needs to go along with that for actually effectuating the transfer of the shares. But by pledging those shares under the grunt fund agreement, the shareholders are saying, we agree that we will reapportion, reapportion them as necessary at the conclusion of the contract.
Now, keep in mind, under the termination rules of slicing pie, a change like this is changing the game on someone. So if someone wanted to quit the company as a result of this change, they would be considered termination with good reason or resignation with good reason, and the termination rules would apply there. Because changing the model of your equity is a significant change that may or may not be what someone signed up for. So you just got to keep that in mind. And someone could depart the company and pitch a fit if they didn't like how things are going, and that's just the consequence of a fixed equity split. But I would consider this resignation for good cause, if the company changed. Now, if you stick with the company, you got to play by the rules. If you want to bow out at that time, you should be treated fairly under the termination rules, which are in the book, and I'll talk a little later about them. What are some alternative ways of accounting for pre-grunt fund contributions? This question arises when you've had a founder or a couple of founders who have been working for a long period of time before the company really got going in earnest. And I say in earnest, meaning that when did you really decide this is going to be a company and we're going to start it? Sometimes companies incubate for many, many years. I've had founders say, you know, I wanted to design a certain website and I had to teach myself how to code first. Well, that doesn't really count because that's just making yourself better. So you got to decide when you started working on the company in earnest, and from that point on, we figure out what your contributions were. And I know, Jennifer, you have some comments on this as well.
Yeah, I mean, one of the problems can arise when, you know, it's been a one-person show for a while, someone that's been working on it, putting some money, some effort towards it for a period of time. Could be weeks, months, could be years that this has sort of been a pet project, until finally you reach the point where it's like, okay, I need some help to really, you know, it's time to fish or cut bait, and we're either going to launch this or not. So at that point, the original person, the original founder, is going to have to enlist the help of others to help to get the business launched, and so is going to need to be willing to give up some equity or some control of the company in order to accomplish that. Unless, of course, you have cash and you can just pay people to do it, in which case you get to keep everything. But the problem there is that the original founder, who's put his or her blood, sweat, and tears into this for who knows how long ahead of time, you know, potentially could have sizable inputs that would need to be accounted for in the Grunt Fund tracker. And that can swamp the pie right from the get-go and destroy the incentive structure that the slicing pie model was trying to put into place, which is that everybody's incentivized to move forward together and as quickly and diligently. So in an effort to preserve the incentive structure while not totally discounting what the original founder had put in previously, one way of doing that is to, you know, negotiate what that value is, and perhaps put into place either a royalty agreement based on that value. It could be a stock warrant for the person to be able to purchase stock at a specific price later. Or it could be a preferred stock award coming with a board seat or something else. And the Grunt Fund is meant specifically for common stock. And so that way, all of the co-founders are moving forward essentially equally to begin with. But that the original founder, or, you know, if there were multiple that had initial things, really, you know, they will be compensated, their contributions will be recognized, but not directly within the pie. It's a way to handle it.
One thing you kind of said there, that the preferred stock, what you're suggesting is that the pre-Grunt Fund value is actually given to the company as sort of a loan to be paid back at a future time with the preferred stock.
Yeah.
I used to recommend things called partitioning and calibration in the Slicing Pie book. I no longer recommend those things. I always want people to stick to the model as cleanly as possible. But this is a great topic of a phone call. I do a lot of phone calls. You can schedule a call with me through slicingpie.com. And I'd often talk to people about this process, getting into a Grunt Fund after the company's already been formed. So I'll be happy to talk to people in detail about their specific situation over the phone. Should a startup bother with different types of shares, founders shares, type A, type B? My personal feeling on this, and I'll let you chime in too, Jennifer, is that in the beginning you want to keep it as simple as possible. I consider a startup company the time during which people are taking personal risk. Personal risk means I'm making a contribution to the company and I'm not getting paid or reimbursed for that contribution. So as long as there's personal risk on the table, everyone taking personal risk should be treated the same with the same class of shares. Once personal risk is off the table, that means the company is generating revenues or has some Series A investment and they're being paid for their contribution. Then you can create incentive programs and option programs and things that create different incentives for different people. But during the startup phase, when people are taking personal risk, I always encourage people to treat each other exactly the same, and creating different types of shares helps muddies that water. It doesn't make it more clear, especially during the early stages. Jennifer, do you have any thoughts on that?
No, I agree with you. I think keeping things as simple and straightforward when you're getting started is the best way. A lot of these types of decisions are distractions from really being able to dig into the substantive growing of your business. And so if the goal is to get a group of people together that can want to work together and work diligently and create something, then the goal is to try and keep it as straightforward but as fair as possible. And so if you're getting into a lot of complexity right at the beginning, I think it's more of a distraction than it's really worth. Because you can get really bogged down with this, and people are then continuing to worry about whether they're going to get screwed or whether they're making the wrong decision or what have you, rather than focusing on substantively building the business, which is the only way anybody's going to get any value out of the venture at the end anyway.
It breaks my heart to see somebody in an early stage spend a lot of money on options agreements and preferred shares and all these different deals before the company hasn't even any traction. And from experience, I've spent thousands of dollars on lawyers in the beginning structuring equity agreements before my company made any money. So I spent thousands of dollars on failed companies. Slicing Pie is designed to be a universal, one-size-fits-all solution for every company on the planet. Now, Jennifer and her colleagues always have a "it depends" thing. I believe that it always should be the same model for everybody. And then once you're established, once you get some traction, that model will naturally turn into a more traditional model where you can start throwing in incentive programs and bonus programs and options programs and things like that. So in the beginning, keep one class of shares and treat everyone the same. That way you can always make sure everyone's getting treated fairly. So this is a question that I get from time to time. And the question is, am I breaking the law, the California law, if I don't pay for work, or is that handled through partnership? It sounds like I can pay helpers with an IOU. If so, how can I go about it? Is it a promissory note? How can I make sure everyone gets paid when the time comes to pay? This comes up, the same issue exists in New York and maybe some other places as these laws develop. In general, my conversations with attorneys from those areas is you are breaking the law if you don't pay people. That's a calculated risk people take. This comes to really comes home when during the termination rules, is you probably have to pay out at least minimum wage to someone who leaves the company. But there's a lot of gray area here. The Slicing Pie will account for the payments of minimum wage. You simply subtract that from a person's salary if you can make it. If you can't pay minimum wage, then you are running the risk of going afoul of the law. But Jennifer, I'll let you chime in to see how they might get around that.
No, I think that's absolutely right. I mean, in a partnership context, it might work. But if you have everybody kind of together, but really it's independent contractors working for the company, yeah, you can easily run afoul of minimum wage laws. I know California has been particularly aggressive in the last year or so, going after that. See the Uber and Lyft and various other lawsuits that are going on. New York is also doing that, and some other states are following suit, or at least paying close attention to the gig economy and all of that. So it's definitely worth talking to a local employment expert about it. It absolutely is a risk of violating the law if you're not paying people anything, if you're just paying people in equity. but if you can get a very senior engineer for minimum wage plus the promise of future equity, it's a pretty good deal. So, to the extent that you can pay minimum wage, it's a good idea to do so. And as an attorney, I can't say otherwise.
I know people all over California that have implemented this model, have implemented this model. I don't know what they're doing with minimum wage. I personally have never heard anybody say, I started a company, I didn't pay minimum wage, and I got into a lot of trouble with it. It doesn't mean it doesn't happen, but when companies like Uber and companies make tons of money, all of a sudden they become a target for enforcement because there's money on the table.
Right.
And there's lots of people being affected. If it's one or two people being affected, it's not as good a time it's an intention for the state to do that. I'm not telling anybody by any stretch of the imagination to avoid paying minimum wage or taxes. I'm just saying you take calculated risks when you start a company. Yeah. And this doesn't seem to be the focus of those laws. They're not trying to protect startup guys. They're trying to protect other people. So
they're trying to protect the employees and making sure that they're not getting taken advantage of. So whether it's an employee or a contractor situation, you can still run afoul of the minimum wage, or some sort of, payment that's reasonable. Just having 1099 contractors does not absolve you, mostly because those 1099 contractors probably aren't, in fact, 1099 contractors. You have to go through a bunch of tests in order to prove whether you're a contractor or an employee. And in all likelihood, because of the way early startups are set up, they're going to be considered employees. They're not going to be considered contractors. So it's a tough situation. It's something I know that's playing out in state legislatures across the country, and even nationally. I've been trying to talk to Senator Warner from Virginia about some of these issues and ways of trying to lower these barriers to entry, because they really are. But unfortunately right now it's, we either try and play by the rules or you're going to take a risk if you don't.
I would love to open this discussion up on slicingpie.com if someone's got some specific ways of working with these laws. I invite them to get in contact with me. How do you make normal lawyers comfortable with slicing pie? A normal lawyer is one who has not been fully immersed and indoctrinated into the slicing pie model, and most of them are going to have traditional views on how this should be done. And most of them will hear the word dynamic equity split and equity compensation and start being very uncomfortable with the model. I think when people fully consume the model and see how fair it is and see how the tax laws are addressed, they'll be comfortable with it. So the key to make a normal lawyer comfortable is to educate them as much as possible. And one way to do that is to put them in touch directly with me, and I'll provide the free book, I'll talk to them on the phone, I'll provide contract templates, everything they need in order to become comfortable with it. In many cases, my slicing pie friendly lawyers like Jennifer and Matt have had conversations with lawyers. If they try to charge you for becoming comfortable with slicing pie, that may be a good time to find a different lawyer. If they become comfortable with slicing pie, that gives them a new tool in their arsenal of things to offer. I know Jennifer does a lot of slicing pie consultations, and I know that Matt in Chicago does a lot of them too. It's a good way to get new business. So a lawyer educating themselves should not be your bill, but certainly they can charge you for the implementation of the contracts. Jennifer, have you had conversations with lawyers trying to become slicing pie lawyers?
I have, actually. I've had lawyers take advantage of downloading the template on your website and then getting the free 30-minute consult with me and talking through it. So I've done it that way. And I've also worked with companies that have local counsel or regular counsel, and they bring in that lawyer into the discussion with me, either through a consult, whether it's the free consult via the contract template, or whether it's a paid consult. But I mean, I personally am always happy to work with other attorneys if you have local counsel. You know, with being based in Virginia near Washington, D.C., it's a limited geography, and so in getting to work with companies all over the country, you know, it's always good to play nice in the sandbox with the other attorneys and the other experts that are helping the businesses. I've also talked to accountants and had accountants involved in the conversation as well as we were going through and implementing or talking through the implementation of it. You know, you run the risk of having to pay twice, you know, having to pay the slicing pie expert plus having to pay your local counsel to get educated. Or if they're going to charge you some billable hours for reading the book. But if an attorney is doing that to you, that might not be the best attorney for you. And I'm not saying, you know, oh, well, come to me, which of course you're more than welcome to, and I would love to have you. But you always want to make sure that you're working with an attorney, an accountant, an insurance advisor. You know, these folks are there to help you. And if they are making things more difficult and they're standing in your way, they're throwing up obstacles without providing you ways around those obstacles, they're the wrong people to be doing business with, just plain and simple.
I heard a story once where the attorney offered to write a slicing pie contract for $20,000 for a startup company.
Wow.
When I hear stories like that, I know that attorney does not have the best interest of the startup in mind. You can buy a template off my website for $50 and have a slicing pie attorney do a consultation, and that should get you on the road to proper legal support with this program. Any attorney that works with startups should be sensitive to the needs of startups and the financial restrictions of startups. I've worked with attorneys in the past that have not been sensitive to those, and I've spent thousands of dollars of my own pocket on things I didn't necessarily need. So you need to find an attorney who's sensitive to what startups need and can put things in place without a lot of fuss. If your attorney is interested in becoming familiar with this model, I'll do everything in my power to make sure they get everything they need to make some good decisions on your behalf and along with you. So please know that is definitely an option available through Slicing Pie and through Slicing Pie friendly attorneys. So one question we got is, how do you transition to a traditional framework at Series A investment? And I'll take you through some more information on this, but I call this freezing the pie. So let's pretend we have a pie. The slicing pie is split up like this: 14% for the salesperson, 30% for the founder, and 56% for the rich uncle who funded the whole thing. So eventually, these people are all contributing things over time, and the slicing pie model has done a split and given this as the final split. Eventually, you want to freeze the pie, and there's two times where you can freeze the pie. The first one is when you generate revenues in excess of your expenses, and your expenses should include the salaries people deserve on the open market and all their associated expenses. So once you generate enough revenue to cover your expenses and salaries, then you have profits. And as long as the expenses are being covered, you no longer are accruing pie. Same way with the Series A investment. When a Series A investment comes in, and I consider a Series A investment around during which enough money is raised to pay your expenses in the foreseeable future. So let's take, for example, let's say you're someone who can earn $100,000 on the open market and they're not paying you anything. You apply the slicing pie model, and that will give you 100 slices per hour. That means every hour you work there, you're contributing 100 slices per hour. Now, if the company raised some money and could pay you $25,000 a year, your risk goes down. So the number of slices you earn per hour goes down. You still have your 100 slices an hour from before, but now you're only earning 75 slices or contributing 75 slices per hour. And so on, if you can get paid more and more and more based on how much money you raise. Eventually, you would pay your entire fair market salary. You're no longer taking personal risk, and the model freezes naturally, and that will determine your traditional split going forward. You would issue all those shares and put your documents in place, and now your investor would go through with a typical equity model, you might have reverse vesting or option program, whatever the venture capitalist or major investor requires of you. So to transition, you just start paying people until the slices are no longer accrued, and the traditional models would apply. And one thing that's interesting about, and we'll get to this a little bit later, there's another question about it, is people who invest in startup companies care that the founding team is all in agreement with regard to their cap table. And Slicing Pie is a nice way to deliver a very healthy, organized cap table to an investor. Are there any comments you want to add there?
No, I think that, yeah. And the best part of the accounting feature, either from the download from your website or one that you set up, is that, yeah, you get a snapshot of the cap table at any point, which is great because then you don't have to educate your potential investors or anyone else about your Slicing Pie approach. It's really irrelevant.
Once the pie is frozen, the profit, the excess revenue that comes in over expenses is your profits, and they will be divided up according to the pie. And if your investor comes in, then the proceeds have to be shared with that investor as well. So for instance, if you negotiate a $900,000 pre-money valuation and raise $1 million, the investor would go in at a post-money valuation of 1.9, and the split would look like this. So a traditional investor now has 53% of that company. The founders have all been diluted fairly, given their ownership in the pie, and the proceeds are now shared with that person. So Slicing Pie just naturally turns into a traditional split once the money starts coming in. Which brings me to another question. How do we handle forfeited equity or due to resignation without cause or termination with cause? So this implies, and I'll go through the termination rules. So here's our team of folks in this particular pie. We got 4 guys. Each owner split of this equity pie. And this question was referring to resignation without cause or termination with cause. That means they're fired for good reason, meaning that's termination with good cause. That means they didn't perform on the job and got warnings, or they stole from the company, or they sexually harassed somebody or brought a gun to work, and they had a good reason to be fired. Or if they resigned for no good reason, resignation without cause, meaning they just left the company in the lurch for their own reasons, they just got up and quit one day. In those situations, the company is worse off. The employee has made decisions about their own behavior that leaves the company in a bad position. It negatively impacts the future of the company, and the company deserves protection from that. So if they're fired for good reason, or they're terminated for or they resign for no good reason, they would lose their pie for non-cash contributions. This means the slices just sort of vanish out of the pie. That risk is taken off the table because they're no longer participating in the game. You don't give them to somebody else. They just vanish. You buy back if possible. If they're, on the flip side, if they resign for good reason, meaning that the company changed their job or their location or something that would give the good reason to quit, or they're fired for no good reason without warning, they would get to keep their pie. In that case, the slices stay in the pie, or they're bought back at $1 per slice. So here's an example. Here's our team. We're going to pick someone to fire for a good reason, according to the question. And let's pick that grunt number 1. He wasn't doing his job, so he's fired. All you do is take his slices out of the base, and you recalculate everyone's share. There's 1, there's 2, 3, and 4. So the pie would now readjust appropriately. Those slices just vanish. If the person left on different terms, they might keep their slices in the pie, which they would continue to dilute over time as their risk relative to the rest of the group went down. So it's an important thing to keep in mind that the slices just sort of vanish. Any comments on there, Jennifer? You had experience with that?
No, I don't think I've got anything to add. I've also been fielding some questions in the webinar chat box, so been tuning you out just a little bit.
We'll get to some of those questions at the end too.
Yeah.
The next one is, we're interested in alternative types of buyout liquidation points if you're not anticipating influx of capital or loans. So this is great. This means you guys built the company on pie alone, and someone wants to get out of the pie. They want to liquidate their holdings. And I'll go through this model, and Jennifer, I want you to chime in on some securities issues that might arise. But basically, let's say we have 3 people in the company that have all earned slices, and they all want money. If they all want money, the pie will determine their split. So based on their risk, based on the slices they have, the pie will determine how much of that money they get. So the company will decide how much money they can afford to distribute and pay it out to all the founders. In that case, they all stay in the company and there's no issue. However, if just one of them wants money, that's a different issue. That means that person wants to get out of their holdings of the equity or the pie, and they want to do that in different terms. There's a couple of situations. The first one is when somebody else on the team offers to buy those slices. And I always suggest a 1x buyout because you're basically removing risk from the table. So that person would pay the other person, and those slices would simply go over to the other person. And the company would have to account for that. The other situation is if they want more money, or they want money and the company wants to buy the slices. If the company buys the slices, that means they have excess money in the bank, and they simply pay the person 1x for their contributions to take the risk off the table, and the slices just kind of vanish. So the slices just come out of the pie as if they're terminated for no cause, for good cause. So the slices no longer exist, which naturally gives everyone else a bigger share. So depending on how you transfer those shares, will depend on whether or not it's legal to do in your state or according to your bylaws. But there are mechanisms where you can exchange shares between members. I would not recommend selling them to outside members. You can run amok of some more securities draws pretty quickly, I think. Jennifer, any comments on that?
Yeah, absolutely. You definitely need to watch out for if you were looking to sell shares outside the company or outside of the folks that are actually working for the company. So yeah, so it's not that hard. I mean, there's some paperwork that would be involved, and it's more following the provisions that are either going to be in your company's bylaws or in the restrictions in the stock purchase agreement, as to who gets the first right of first refusal on reclaiming the shares, and how you go about transferring that, and whether or not the company has to approve it. In all likelihood, it does. So, but yeah, I mean, in a standard context, it's typically offering it to existing shareholders so that they'll take over the shares. In this context, they're taking over the slices or the potential future equity. But yeah, it makes it's an unusual situation, and it's probably best, in order to again preserve the fairness factor, to have the company take the shares back and pay out the departing grunt, and then if someone else is interested in buying them, then that grunt can put in a cash investment into the company and get the shares that way.
Right. Shares are not really assets to be marketed on the open market.
Yeah.
I'm not saying exactly. They're just measures of risk. So if
Yeah.
the company can reduce the risk by paying the person, or another person can reduce risk, it should be treated as a risk reduction, not an exchange of assets. We're running out of time, so we'll go a little faster. How to deal with absentee pie holders, big and small, in forming legal structure. Should they be issued different class of shares, for example? Generally speaking, an absentee owner is someone who owns shares that's no longer involved in the company. Given that they were part of the original pie and they still took risk, my recommendation is to treat them the same as everybody else. The minute you issue a different class of shares, you're changing the risk profile of that company, that investment at the time, or whatever else they put in. So while it's not desirable to have absentee owners, you got to deal with them if you have them. And I always think of an absentee owner as someone who doesn't like you and has shares. Someone who likes you and is like on good terms should be cooperative with whatever shares that they have. Any comments there, Jennifer?
No, I think that's right.
All right, here's a big one. We have used a slicing pie model, as in the book, with slight modifications, which I rarely recommend, by the way. Introducing an intermediate between good leaver and bad leaver in case of well-prepared voluntary leave. Good leaver and bad leaver, this question sounds like it might have come from the UK. That's the terminology they use in the UK. When we attributed equity in the proportion of the slicing pie model, we'll keep the model alive legally using periodically awarded stock options. However, We're in the drafting of legal agreements regarding the exercise of stock options and the obligations related to equity, particularly legalize good leaver, bad leaver events. I would love to hear your thoughts on the subject. I'm not 100% sure I understand this question, but I took a whack at putting some slides together. This may be the case of someone who, I kind of interpreted this as someone who, this well-prepared leaving, let's see here. If someone's a good employee and they just can't afford to work for free anymore, but they put some time in, I call this a loyal employee protection clause, which means that any shares they earn before a certain amount of time they get to keep, even if they leave for no good reason. This will protect people from having too much burden of quitting when they have to, because they have family reasons or personal reasons where they got to quit. They shouldn't lose everything. There should be some penalties in place, but it doesn't mean you have to take everything from them. So you just want to be sensitive to people's particular needs. If someone gets fired for good reason, I wouldn't give them the same protection, because you don't want someone to just stop behaving on the job and you still get shares in your company. So how do I bring on partners and VCs later on in the process, and what do professional investors think of slicing pie? I have never heard ever of any professional investor looking at a slicing pie deal and saying, I'm not going to invest because you use a slicing pie deal. I've heard people concerned about that, just as these people are asking the question. I've never actually heard that actually happening. What I have heard is that when professional investors look at a slicing pie funded company, they rejoice in the amount of detail and records that are kept, and what kind of, during due diligence, they know exactly who did what, how much money was spent on what, how much time was spent on what kind of investments were made. So it's really a wonderful thing for an investor to have, is a documentation that a company is slicing pie. But as Jennifer mentioned before, what slicing pie will produce for you is a cap table. And the cap table is what it is, and you should present that to your investor and treat this like a normal negotiation for valuation, and raise whatever money you can raise. And if they ask about the process by which you created your cap table, you can go into more detail, but it's not necessarily part of the discussion up front. But doing due diligence, you can certainly produce some of the record keeping that you did during slicing pie. So just treat it as a normal deal. Any comments there, Jennifer?
Only to say, I agree with you, and only to say that the whole reason that I became a slicing pie friendly lawyer after reading the book was the fact that by using this model and going through the system of putting these different agreements and things in place, it's forcing a startup company to take itself seriously, that it's a real deal. It's getting all of its co-founders on board and on the same page right at the beginning, because these are difficult conversations, and they only get harder the more you put them off. And so it's very easy in the chaos that is involved in a startup company to say, oh, well, we'll get around to figuring that out later. Oh, well, you know, we're just a startup. We don't need to document that kind of stuff right now. And it puts you in a world of hurt when you have to start doing due diligence and answering questions, you know, from outside stakeholders. So the whole reason that I really jumped on board the slicing pie model was really how it really forces a startup company to take itself seriously as a real company, and all of the attendant benefits that come along with that. It tends to resolve a lot of the early issues that can completely derail a startup that have absolutely nothing to do with the substantive business or market case that you're trying to make.
All right, moving on. Angel investors funding, VC funding, Series A, B, C, and how the pie changes legal terms and conditions. We've talked at length today about what happens when the pie raises enough money and starts paying everybody. The pie naturally freezes. Angel investments, in my book, represent money that's not enough to meet your immediate financial needs on the medium term. So when you get an angel investment, I always push people towards a convertible note, which is sort of the fair market value of doing that. Angel investments from founders can be treated as part of the slicing pie model using a 4x multiplier. Angel investments from arm's reach investors should be treated as a convertible note, and VCs should be treating the pie as frozen because they're going to start paying for everything. So the pie changes from a traditional model, from a slicing pie model into a traditional model, and you're going to be subject to the terms and conditions of the professional investor, whatever they are. And VCs often bring in reverse vesting and termination clauses and things that they're more comfortable with. So that's part of the negotiation. And that goes on. So by the time you get to B and C rounds, your slicing pie is hopefully long behind you.
Exactly.
What responsibility does a startup founder have in keeping his grunts informed regarding the status of the company's growth and what it might mean to them as investors? This speaks to transparency, and I think they have a responsibility to keep people informed of what's going on in the company, and hopefully that's not going to be an issue. Sharing the details of someone's slices in the pie is a personal decision. Some companies really like to have the transparency and know how many slices each person has. I think at a minimum you should tell someone how many slices are in the pie and how many they have so they can calculate their own shares. But if you want to open it up a little more and provide the transparency so everyone knows what each person has, that's logical. In the United States, there's sort of a taboo against sharing salary information and things like that. Hopefully your team is open enough you can share that comfortably, but don't feel like you should be pressured into that. Negotiate the salaries that make sense, and you can keep them private if you want. But it's just more your personal taste. But certainly you'd want to let people know that if there's an investment event coming around the corner. If I have grunts internationally, India in this case, how do I implement this model? What type of operating agreement should I consider? Currently asking them to track both cash and non-cash like time relations, etc. I'll let Jennifer comment a little bit on this, but I do want to let you know that one of the advantages to going overseas to secure employees is because it's less expensive. So the market value of someone's salary in India is going to be lower than their market value in the United States. And that's a business decision people make. They should always look for cost-effective ways to get services. So their market value is going to be less if they're based in India versus if they're in the United States. I don't know much about how to implement internationally legally. Jennifer, have you had any experience in that realm?
Well, I think that's it's going to come back to carefully drafted contracts, and it's going to require, both the grunts internationally to have local counsel on interpreting it, and what they're doing for purposes of their own tax laws and everything else. And I certainly can't comment on India's laws, but I think it's, you're going to have these grunts that are going to sign the grunt fund agreement, so they agree to the structure, and then you're also going to have a separate either employment agreement or independent contractor agreement with them for the work that they're, for the scope of work that they're doing. Again, I think it's going to require both counsel in the U.S. and in India. If the company is based in the U.S., it's appropriate that the law used to interpret the contracts is U.S. law, but that doesn't absolve you from the grunt needing to fully understand what it means.
And different countries have different treaties with the United States, and certainly the contract law will pass through that filter.
Yeah. So so it's a complicated issue. It definitely can require some more outside expert assistance, but I think it's still doable.
I always encourage people to honor the spirit of the slicing pie agreement, even if it's not in the spirit of the local laws. Not breaking the law, but if the law allocates more to them than they deserve, it's in the spirit of slicing pie not to take it, as far as I'm concerned. I worked with a guy once where he forced everyone to sign a legal agreement allowing him to buy back their shares if they were let go for any reason. It was perfectly legal, but it certainly wasn't fair. The spirit of the slicing pie law, the spirit of the slicing pie agreement is to be fair with people. So even if the law will grant you more than you deserve, you shouldn't actually take it. That applies no matter what country you're in. What if we don't want to create an egalitarian agreement? What if we want to create a manager-managed LLC where the manager holds a significant amount of power compared to the other members? What if we give him Class A shares with economic and voting rights, and the other members Class B shares with only economic rights attached? Would that destroy the slicing pie model? This is an issue that comes up. People want to maintain control, and I think it's fine, personally, for one person to own the whole company or be a manager manage LLC. I refer to this as profit interest. So ownership interest implies ownership and decision-making rights, whereas a profit interest only provides a share of the profits or the proceeds of a sale. So it has the same economic benefits of equity without the underlying legal benefits, control benefits of equity. So you can do this through profit interest. It doesn't destroy the slicing pie model, but if someone is hell-bent on keeping ownership, then they should be comfortable doing that. And this would be mostly the case where a lot of money is raised and ownership would be almost immediately taken away from them, but allow them to maintain ownership and decision-making control without giving up, without risking the company decisions being made without them. So, Jennifer, do you have any experience with profit interest agreements? I have one on my website I can send to people if they want one.
Yeah, I do have experience with that. Been working on actually putting together kind of the slicing pie approach to profit interest template. And yeah, it absolutely works in situations where you need to protect the ownership and control of the company, but still incentivizing other people to work in it. So you're willing to share in the economic benefits of the company, but not in control of it. So profit share type of arrangement is great. Again, this is a reason why you don't want your slicing pie model, whether it's for equity or membership interest or whether it's for profit share, rolled up in your governance documents. You want to keep your governance documents and your slicing pie related agreements separate.
So we're about out of time to go with the questions. I want to bring your attention to a few resources that are available for you online as you explore the slicing pie model for your own business. There's 3 books that I've written on slicing pie. One's called Get Them Gators, which is a short book about making the case for dynamic equity, which you can share with co-founders. It's very cheap. It's $1 on Amazon, and I'll send it to you for free if you want. And you can distribute it freely. It's about convincing people to work with the slicing pie model. Slicing Pie is the original book I wrote in 2012. It's been modified a couple times, but it's what most of you probably read. It's very popular all over the world. There's a new book coming out very soon. It's called the Slicing Pie Handbook, which is an implementation guide for slicing pie. It's a complementary guide. It can be used independently or with slicing pie. It just describes in more detail how to implement. It's sort of a rewritten book, and it includes a retrofit guide that's on the website. So it includes some information that's not in slicing pie. I will get around to modifying slicing pie a little bit with some new lessons that I've learned. But the Slicing Pie Handbook is nearly ready to be distributed. So keep in touch to find out more about that book when it comes out. Slicing Pie has been translated into a number of languages. We've got Spanish, Chinese, Polish, and Dutch, with about half a dozen languages coming out over the next year or so. So keep an eye for your native language if you're in different countries. The book has been translated. There's website software that'll help you do your split for you. It's called the Pie Slicer, and it's a free trial online, but it allows each individual person to add their own contributions and gives them the pie split in real time. Of course, there's articles and videos. This video will be posted there, hopefully not too long. Spreadsheets for keeping track, case studies, templates for letters and advisory letters. There's even a slicing pie game that you can download and play with your co-founders to kind of get a feel for how this thing unrolls over time. There's books, there's software, there's legal agreement templates. You can also book a phone call with me directly to talk about your specific issues. If you want to get in touch with me, it's mike@slicingpie.com. If you want to get in touch with Jennifer, this is her contact information. This is her Twitter, jrollaw.com is where she can be reached and found. And you can also download her contracts through my site. And I know that she's got a special offer right now for a couple of services for webinar attendees. You want to go into a little more detail on that, Jennifer?
Sure, and thanks for sticking with us, guys, as we're running a little bit over, and I will keep this very brief. But I have a law practice I launched about 2 years ago after being a becoming a refugee from big law, as it were, as well as a recovering engineer. And I knew I wanted to work with early stage and growth businesses. So I have a law firm, J. Roller Law, and that is all we work with is early stage and small growth business. Outsourced general counsel work, formation work, really anything and everything that comes with getting your business launched and up and running. And we do everything on a fixed fee. So I don't want anything standing in the way of being able to communicate with my clients. The limitation of the value that I can add to your business is only limited by the knowledge of the business that I have. And so if you're always worried about a hidden meter running, and so you're not going to pick up the phone or drop me an email, then the value that I can bring to your business is really, really curtailed. So all businesses, whether they have been going for a little while or they're just starting up, I have what I call a business legal self-audit. And so it's a very quick, 2-page worksheet. You can go through it in 5 minutes, and it gives you a chance to figure out and show you where the biggest outstanding liabilities for your company are. And so it can show you where you should start prioritizing some of your time. I know in startup mode and in a small business, time is always a very precious commodity. And so helping you to prioritize what you should be worrying about first, I think is really important. So in a follow-up email to this webinar, you'll be getting an email from me, and it will have a link where you can download that self-audit. In addition, I am offering what I usually charge $600 for, is a comprehensive business legal audit. And so this is taking that self-audit and going further. It's a 90-minute session with me or my team, and using that self-audit as a starting point, but really diving into the current status of your business so that you walk away with a much better understanding of your business and a prioritized action plan on how you start eliminating or mitigating any of the big holes that are in your business. Some of those holes might be things that you can take care of yourself, a DIY, which is near and dear to every startup owner's heart. Some of it might be I need to talk to my accountant, my insurance provider, something like that. And some of it is going to be some prioritized legal assistance that you may need. So whether you have a local counsel or you want to further work with me, I'm happy to discuss all of that. But at least, at the end of that 90-minute session, you're going to have a report that gives you a roadmap on how to make your business stronger so that everything that you're doing to substantively grow your business is being built on a strong foundation. So as I said initially, I usually charge $600 for that, that business, that comprehensive, the comprehensive business legal audit. And as a registrant for today's webinar, I am offering you the opportunity to book one of those for $399. So again, the email that's going to be coming to you post-webinar will have information on how you access that. I'm sure Mike will have more information about where you can access a replay of today's webinar. And make sure you really take some time on Mike's website. He's got an amazing number of resources on there. That's also where the templates for purchase are available. So there is a template that I put together, and so with that $50 purchase comes a 30-minute consult with me that you schedule after you purchase it. And I know there was a question about Oh, the LLC related agreement template that's also on Mike's website. And since I've been so vehement about being anti-LLC and keeping the slicing pie documents separate from the governance documents, I in no way am disparaging that other template. And if you have an LLC and everything's working for you, then it absolutely makes sense to use it. I just personally think that as you start asking more questions, and have more complexity around where your business could be going, it's a lot easier to keep the grunt fund, slicing pie model related documents separate from the governance documents of your business. You can always unwind it later, but I think it's probably easier to manage if they're separate from the start.
So this concludes our legal clinic today. We're a little bit over an hour. There were a lot of questions in the margin and in the chat boxes. I'm sorry we didn't get to all of them. I'll try to look through them and post some things to my blog. Certainly there's some offers been made for you to engage Jennifer in some more legal services if you want. My goal as the author of Slicing Pie and the promoter of this model is to make this as accessible and inexpensive as possible for you. So please don't hesitate to contact me through slicingpie.com, and I'll put you in touch with the right people. Thank you very much for watching, and have a wonderful day. Signing off from Slicing Pie headquarters. Thank you very much, Jennifer.
Thank you.